Welcome to Trendy Flix, your ultimate destination for the latest in movies, TV shows, and streaming trends. Subscribe now and stay ahead of the entertainment curve. The eyebrow-raising legal theory behind Alvin Bragg's case against Trump. It's important to take a minute to digest what the prosecution had to prove, beyond a reasonable doubt. It took a jury 2 days to find former President Donald Trump guilty of all 34 counts of falsifying business records in the first degree, proving that Manhattan District Attorney Alvin Bragg's somewhat risky approach to prosecuting the hush money case was a sound choice. Soon after Bragg's office brought the first indictment against Trump in April 2023, 3 other felony indictments were returned in 3 other jurisdictions: Florida, Georgia, and the District of Columbia. As the cases wound their way through their respective state and federal court systems, the expectation was that Trump's D.C. federal election interference case would go to trial before any of the others. Many were therefore surprised when it was announced that Bragg's case would be the first to go, and the somewhat delayed scrutiny into the New York election interference case kicked into overdrive. When the indictment was unsealed in April 2023, it revealed 34 felony counts of falsifying business records in the first degree, in violation of New York penal law, sections 17 to 152. It's important to take a minute to digest what the prosecution had to prove, beyond a reasonable doubt. Trump, with the intent to defraud, made or caused to be made false entries in an enterprise's business records, and his intent to defraud included an intent to commit another crime or to aid or conceal the commission thereof. What is the other crime that the prosecution said Trump intended to commit or to aid or conceal the commission of? According to Assistant District Attorney Joshua Steinglass, that would be New York Election Law Section 17 to 152. Conspiracy to promote or prevent election. Any 2 or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means. The Manhattan DA's office has prosecuted a number of falsification of business records cases. These are usually straightforward, run-of-the-mill paper crimes. Bragg has even referenced them as the bread and butter of his office's white-collar work. But it's the added element of the another crime that raised eyebrows, and this is the heart of the novel legal theory that Bragg chose to employ in this trial. The Washington Post reviewed the New York State Law Reporting Bureau as far back as 2000 for any relevant case law regarding this specific statute. The report found 2 entries in which a judge issued legal opinions on the statute. Both were from Judge Dwan Merchan last year in rejecting Trump's motions to have the case dismissed. That's how rarely Section 17 to 152 is prosecuted in New York. And that fact makes Bragg's decision to primarily premise the prosecution of a former president of the United States on that statute even more novel. Bragg is an experienced prosecutor. He graduated from Harvard Law School, clerked for a federal judge, worked in the New York Attorney General's office as a federal prosecutor in the Southern District of New York, and was a law professor at New York Law School. While at the SDNY, his case focus was on fraud and money laundering cases, as well as public corruption. He knows his way around the courtroom and is no stranger to Trump prosecutions. He led the team at the AG's office that successfully prosecuted the Trump Foundation, for which it was dissolved and Trump made to pay $2 million in restitution. Bragg had the right combination of book smarts and street smarts to bring this indictment against Trump, and the wisdom to see this case for what it truly was. In an interview with WNYC, he declared, "The core is not money for sex. It's about conspiring to corrupt a presidential election." As you may recall, Bragg's predecessor, Cyrus Vance Jr., began investigating Trump as far back as 2019. Vance has advised that his investigation began in and around the same time as that of the Southern District of New York. In fact, he says that the SDNY told him to stand down, which he did for over a year. Vance ultimately decided not to prosecute Trump or